evening, everyone. On behalf of the Federalist Society Student Division and the St. Louis University Federalist Society, welcome to tonight's Feddie Night fight between Patrick Charles and Stephen Halbrook. My name is Leah Hovland, and I'm the president of the Federalist Society chapter at the St. Louis University School of Law. I am honored to introduce our distinguished fighters as well as our referee. First, our referee, Ms. Barbara Smith. Barbara Smith is a partner and co-chair of the Appellate and Supreme Court group at Bryan Cave in St. Louis, Missouri, and an adjunct professor at Washington University School of Law. Barbara earned a BA from Wake Forest University and a JD from Stanford Law School. Barbara served as a law clerk to Justice Samuel Alito on the United States Supreme Court and Judge Thomas Griffith on the United States Court of Appeals for the DC Circuit. Barbara previously practiced Supreme Court litigation, where she represented clients before the United States Supreme Court and various federal courts of appeal. She also serves on the steering committee for the St. Louis chapter of the Federalist Society. And now for our fighters, starting with Mr. Patrick Charles. Patrick Charles is an author, historian, and legal scholar that primarily focuses on how to properly use history to adjudicate constitutional questions and controversies. Patrick received a BA in History and International Affairs from the George Washington University, a JD from Cleveland Marshall School of Law, and an LLM with distinction from Queen Mary University of London. He is the author of over 50 publications, including the 2018 book, Armed in America, A History of Gun Rights from Colonial Militias to Concealed Weapons. Patrick's writings have been cited by several federal appellate courts and the Supreme Court. Next, we have Mr. Stephen Halbrook. Stephen Halbrook is an author, senior fellow with the Independent Institute, former professor of philosophy, and practicing attorney in criminal defense and civil rights cases for over 40 years. Stephen earned both a BS in business and a PhD in philosophy from Florida State University and a JD from Georgetown University Law. He is the author of numerous publications, including The Right to Bear Arms, a constitutional right of the people or a privilege of the ruling class, as well as the Founders' Second Amendment and Freedmen, the 14th Amendment and the right to bear arms. All have been cited in U.S. Supreme Court cases. Stephen has argued and won in the Supreme Court cases of Prince versus U.S., Castillo versus U.S., and U.S. versus Thompson Center Arms Company. At the end of this evening's debate, we will open up the floor for questions from the audience. You must be logged in as a participant in the Zoom webinar in order to ask a question. Please use the raise hand function in Zoom to enter the queue. When we get your question, our moderator will call on you by name, and the Zoom host will unmute your microphone so you can ask your question. If you are calling in from a phone, you can press *9 on your phone to raise your hand. And with that, I will hand it over to our distinguished moderator, Barbara Smith.
Thank you, Leah, and thank you to the St. Louis University student chapter for hosting this interesting and prescient debate this evening, and of course to the Federalist Society National Division for providing us this online platform to have such a great discussion. We've collectively gathered tonight at the Federalist Society's virtual OK Corral for a shootout on the meaning of the Second Amendment's right to bear arms, including its scope and applicability outside the home, particularly the applicability of the right outside the home for purposes of self-defense. For those of you who saw the flyer for tonight's debate, you'll recognize me as the sheriff/moderator. And my Wild West code name for the evening is Belle Starr. Belle Starr, of course, is a well-known female outlaw and gunslinger. That makes me both a sheriff and a gunslinger, which I take to be something like akin to a law firm partner and gun enthusiast. And since this is a virtual debate and I can't see any of you, I'm just going to assume that that opening joke got a couple of laughs. But of course, no one is here to listen to me and certainly not to hear my jokes. So I will only talk briefly at the beginning to lay the groundwork a little bit, get us all on the same page about the scope of tonight's topic, and talk a little bit about how the night will progress procedurally. So first, why are we here? As I'm sure all of you know, the Supreme Court in a recent decision called District of Columbia versus Heller decided that the Second Amendment's right to keep and bear arms included and constituted an individual right that applies, including inside the home for purposes of self-defense. And in reaching that conclusion, the court looked not only to the text of the Second Amendment, as Federalist Society members everywhere were glad that it did, but also looked to the history and tradition of firearms regulation in order to understand the scope of that right. The court looked not only to the history and tradition we knew and understand at the time of the founding, but history and tradition since then, and also went back in time to try and understand the English common law understanding of the right to keep and bear arms in order to inform the court's understanding of what the meaning of that term is. So this term, the court again faces a Second Amendment question and will again be forced to confront the history of firearms regulation. And in this context, in this case, the New York State Rifle and Pistol Association versus Bruen case, the petitioners applied for concealed carry permits under New York State's permitting regime and were denied unrestricted permits, granted concealed carry permits for some purposes, but not for purposes of carrying outside their homes for self-defense. And that's how the case sort of got to where it is before the court. So as I suggested in answering the question whether New York State's permitting regime violates the Second Amendment, the court's likely to look at the history and tradition of firearms regulation going back perhaps as far as 1328 and through and including firearms regulations as they exist in the various states today. So to help us understand what the court might be dealing with, how it might weigh that history, we're lucky tonight to have two of the nation's foremost historians on firearms regulation to talk about their view of what that history means. Just to lay the groundwork in terms of how tonight will unfold, we will start with Patrick, who will give us his view for about 20 minutes on the history and tradition of those regulations and how they're applicable, if at all, outside the home. Then Stephen will respond for about 20 minutes. Patrick will give you a chance at rebuttal if you'd like it for 5 minutes or so. And Stephen, if there's a need for any rebuttal, obviously we'll give you that opportunity as well. But I do hope after that we can move relatively quickly to the Q&A portion of the evening. I've prepared a couple of questions for our participants, but I see a number of you have logged in and are already, hopefully excited and listening, and will have some questions of your own. So as you think of those, as Leah suggested, if you could utilize the raise your hand function on Zoom when you have a question. Once we get to that portion of the evening, I will call on folks and you can ask your question of the panelists. So, all right, with all of that groundwork laid, Patrick, Stephen, I think it's time to load up and take aim, and it's time to ring the bell. Maybe we'll start without a bell. All right, there we go. Patrick, the floor is yours.
All right, good evening, everybody. I'm Patrick Charles. I'd like to start off by thanking the Federalist Society, for inviting me here tonight. Leah for that kind introduction, and for Barbara for taking time out of her day to judge and adjudicate this event. Let me start off by saying I think it's very fitting that Stephen and I are talking before you today, squaring off on this timely topic, because it's through our scholarship that both litigants and Bruen have premised their respective historical arguments. Can you go to the next slide, please? In District of Columbia v. Heller, the Supreme Court was clear in noting that the Second Amendment extends in some capacity beyond one's doorstep. As to exactly what capacity, Heller is rather cryptic. While gun rights proponents have consistently argued that Heller enshrined broad carry rights, the lower courts have been unwilling to accept this reading. As for my opinion as to what rights are guaranteed by the Second Amendment outside the home, if you ask gun rights proponents, it's alleged that I support negating or canceling the Second Amendment altogether. That's not true. Based on what I know about the history of gun rights politics, such inaccurate characterizations of my work appear to be nothing more than an attempt to frame the debate in simple pro-gun and anti-gun terms. But in other words, what they're trying to do is create a false dichotomy by alleging only a broad interpretation of the Second Amendment is the right one. Whether or not this attempt at political framing will actually persuade the Supreme Court in Bruen remains to be seen. Right now, based on oral arguments, I assess likely 3 justices may lend this credibility. But garnering the support of 5 justices, however, will be difficult. It's not impossible, but difficult. What I can assure everyone here tonight in this forum is that I do not support negating or canceling the Second Amendment outside the home. I concur with Stephen. You know, if we're going to take Heller seriously, the Second Amendment right to bear arms cannot stop at one's doorstep. At the same time, however, if history and tradition will indeed inform the Supreme Court in carving out the scope of the Second Amendment, until recently, it was widely accepted that carrying dangerous weapons in public places could be severely restricted and even prohibited. Still, with that said, under any history and tradition paradigm, it is my contention that the Second Amendment guarantees at least 4 qualified rights outside the home. You go to the next slide. Can you go back? No, that's it. No, that's right. Go forward. You're right. The first qualified right is the transporting illegal arms for lawful purposes, you know, from shooting, for hunting, to and from a residence. The second qualified right, I think, is worth recognizing is that of carrying legal arms for self-defense, if a person's life is gravely threatened and the carrying of arms in that instance would be deemed reasonable. The third and fourth qualified rights are intimately tied to the first, and they really are about a right to transport arms, whether it's for training or to take part in firearms commerce. Now, each of these qualified rights I just mentioned can be regulated or restricted by what's known as the police power. As to how far the police power can restrict these rights depends on several factors, but given my limited time, I want to focus on the first 2 rights listed here, briefly outline how we got where we're at today, and why I believe history and tradition supports my view. Now, generally one would start with the founding generation and work their way forward, but tonight, given that my work is often mischaracterized, I thought it best to provide you with a 20th century snapshot of the right to keep and bear arms. That is prior to the advent of the standard model Second Amendment, and this view being that the Second Amendment protects broad carry rights, both in private and public, and any restrictions on that right should be subject to strict scrutiny. Can you go to the next slide? Here are several statements from the United States Revolver Association, the first organization to actively advocate for Second Amendment rights. As you can see, the Revolver Association not only supported restricting the carrying of firearms in public places, but the association was crucial in proliferating may-issue firearms laws, like the one currently at issue in Bruen. The association described may-issue laws as sane and reasonable, and understandably so, seeing that they were widespread at the time. In fact, may-issue laws date as far back as the 1860s, a period when the first modern firearms controls were being discussed and developed by lawmakers. Can you go to the next slide? In the 1920s, the NRA partnered with the Revolver Association in its fight to protect the Second Amendment. Over a short period of time, the NRA effectively commandeered that movement, including the association's push for may-issue laws. From that point in time until the early 1970s, the NRA maintained that the Second Amendment did not protect the right for individuals to go armed in public places. That is, unless the carrying was necessary, a permit was first acquired, and I just want to pause briefly so if you need to read a little bit more for the audience. Can you go next slide? Here's some more quotes I think are really important, and I'll pause again so if you want to read. You know, when we put this on YouTube, I'm sure you can go back and pause it and read it, but just to give the live audience some time to kind of look it over for a second here. Can you go next slide? To historically punctuate how gun rights proponents viewed the Second Amendment outside the home prior to the advent of the standard model, here's a 1967 statement from Stanley Spiziak, an officer of the NRA-affiliated Erie County Sportsman Alliance, who was seeking to include a right to keep and bear arms provision within the New York Constitution that did not have one. Can you go to the next slide? Here are 2 statements from then California Governor Ronald Reagan supporting the 1967 Mulford Act, which prohibited the carrying of loaded firearms in public and was adopted with the help of the NRA. What makes Reagan's statements noteworthy is they historically echo how gun rights proponents viewed the Second Amendment outside the home for much of the 20th century. In fact, Reagan was arguably the gun rights darling from 1967 up to the end of his presidency. Can you go next slide? Here's a statement from NRA President Harold Glasson. As you can see, Glasson admits that tight regulations on the carrying of concealed weapons are constitutional, but what about open carrying? Today, the distinction is often made between concealed and open carriage to proclaim that lawmakers may only prohibit or restrict one or the other, but not both. However, for most of the 20th century, the NRA and other gun rights advocates did not make this distinction. The Mulford Act served as one case in point. So too does a 1943 amendment to the District of Columbia's May issue law by Congress. The NRA did not oppose that law either. In fact, they supported it. Then there was Glasson's 1969 speech before Duke University, in which he posed the following question to the audience. Quote, does the right to keep and bear arms mean that every individual has a right to carry a gun at all times, concealed or openly, end quote. Glasson answered his own question with obviously not. Next slide. The NRA and other gun rights advocates supported May issue laws as well as laws restricting the open carriage of firearms in public places for most of the 20th century. Is not to say that the NRA and other gun rights advocates supported all armed carriage restrictions. As you can see in this slide, the NRA adamantly opposed laws that would have imposed licensing on the carrying or transporting of firearms by sportsmen, hunters, and shooters for specific, narrowly defined purposes. So you may be asking yourself, if the NRA and other gun rights advocates of decades past supported broad restrictions on armed carriage to include supporting May issue laws, how did we get to the point we are at today? The answer is in part Heller. But I believe the advent and proliferation of the Standard Model Second Amendment, which from its inception falsely claimed that there were no restrictions on armed carriage in the United States until the early 19th century, is primarily to blame. Ironically, 3 decades prior to the advent of the Standard Model, the NRA had admitted the following, quote, regulations covering the carrying of weapons into places of public assembly were common during the colonial period, end quote. How times have changed. You go to the next slide. There are in fact several versions of the Standard Model Second Amendment outside the home that have developed since its inception. However, for the sake of brevity, I have divided into 2 versions, before and after my foray into the history of armed carriage. Here is a rough outline of the model when I initially began researching the topic. From 1976 to the late 1980s, Standard Model writers, like other historians and legal scholars before them, willingly acknowledged that the Statute of Northampton prohibited the carrying of dangerous weapons in public. Where model writers distinguished themselves from their predecessors was to proclaim that after the King's Bench decided the Knights case in 1686, the Statute of Northampton took on a very narrow reading, requiring persons to either carry arms in a terrifying manner or with the specific intent to cause harm. This understanding of the law on armed carriage, according to the model writers, was widely accepted until the early 19th century when many southern states began passing concealed carry prohibitions. It's worth noting, however, that from 1976 to the late 1990s, for the most part, Standard Model writers acknowledged the constitutionality of concealed carry laws. Then in the early 1990s, once historian Joyce Lee Malcolm began publishing her findings on the English history, model writers slightly revised their narrative in 2 ways. The first revision was the claim that the statute's prohibition of going armed was never enforced. The second revision was that the prosecution of Sir John Knight in Knight's case was an insidious attempt by James II to use the statute to disarm political dissidents. As it turns out, this entire revised narrative of the model has shown itself to be historically unsupported, which I will get into shortly. Before I do that, I want to show you how the Standard Model has recently been modified in response to my research. Slide. Initially, my writings on the history of law and armed carriage were not taken all that seriously by Standard Model writers. In fact, in the first couple of lawsuits brought by gun rights proponents challenging armed carriage restrictions in the wake of McDonald v. City of Chicago, several legal briefs, often written by Standard Model writers, went so far as to urge the court to discard my writings as being anti-Second Amendment and inconsistent with Heller. But when the courts ignored those requests, and rightfully so, Standard Model writers began selectively incorporating my research findings, reframing it, and presenting it as proving their original theory. The Second Amendment was drafted, ratified, and generally understood to protect broad carry rights. Here is a breakdown of what notably changed. For one, you have Standard Models now acknowledging the Statute of Northampton was enforced, but only if it was done in a threatening manner with specific intent to cause harm. Secondly, I unearthed a bunch of new sources on Knight's case, but that was reframed by the writers as supporting the right to peaceable carry, which is a whole new claim in itself. Particularly noteworthy is the new claim, albeit an unsubstantiated one, that Knight expressly defended his case on self-defense grounds. There's no evidence for that either. Thirdly, evidence and sources I unearthed is what's referred to as the Massachusetts model, were repackaged and reframed as peaceable carry laws. And the fourth and last change made by standard model writers is that most, if not all, mid to late 19th century and early 20th century laws were tainted with racism or xenophobia. If you've not yet surmised the principal theme being espoused by the writers, it's simply this: permissive armed carriage laws and broad Second Amendment rights were widely accepted. Only bad, insidious actors supported implementing restrictions on the right to bear arms. This is patently false as well. One does not have to look long in the pantheon of history to rebut this pageant of gun rights freedom. So now let's look at what history and tradition do inform the law of no carriage. It's developed an evolution in historical context. Can you go to the next slide? First, let's start with the law on armed carriage up to the late 18th century. It's a historical fact that the Statute of Northampton was enforced as both a prohibition on bringing armed force affray and prohibiting the act of carrying dangerous weapons in public places. I urge all of you to look at the evidence, not just some ad hoc regurgitation of it. Not only does the text of the statute inform this, but so does the statute's enforcement and restatement and legal treatises up through the early 18th century. Unfortunately, given the constable and justice of the peace records during this period are fragmented and sparse, that has been lost to time, as have virtually all records of enforcement of other armed carriage laws up to the late 19th century. What I can tell you is that based on the totality of the evidence, the statute was not an assault with a deadly weapon statute, which is how many standard model writers read it. Second, despite all the historical and legal hoopla over the Knights case, to this day there remains no evidence suggesting the case was a watershed moment on the law of armed carriage, nor that anyone interpreted the case as enshrining a right to peaceable carry. Historical claims such as these are based on historical conjecture. And historical conjecture, as I put in my amicus brief before the Supreme Court, is simply another phrase for historical fiction. Now, I must admit an error on my part, right? Initially, when I researched and unearthed the evidence on Knight's case, and I placed it on the timeline put together by the aforementioned Joyce Lee Malcolm, I concluded because the incident in which Knight was indicted involved government officials, and the government officials were later exonerated for their actions, that I presume Knight was also likely exonerated as well on similar grounds. In fact, few know that Knight himself was a government official for many years, but not at the time he committed the act. However, after consulting with Tim Harris on the timeline of events, I learned that Knight was prosecuted for a later event where government officials were not present, and subsequently retracted my position. So why was Knight ultimately acquitted, I think is the basic question. And the honest to God answer is historians don't know. The best educated guess is that Knight was acquitted because the jury maintained the same anti-Catholic views that he did when he went to arm to church that day and ridiculously claimed that all Protestants would be murdered by James II. At least one contemporaneous historical source lends credibility to this view. However, one can never be sure. What I can say about Knight's case it was not, repeat, not a watershed moment on the law of armed carriage. We have no evidence of that. Nevertheless, if you read several briefs in Bruen, it is alleged the opposite is true. As historical support for this assertion, it is noted how copies of the English reports, which contain Knight's case, were housed in public and private libraries that Sir William Hawkins, and also that Sir William Hawkins cited Knight's case in his section on the Statute of Northampton. While both historical points are indeed true, there is still no actual certifiable proof that the founding generation viewed Knight's case as enshrining the right to peaceable carry. The point to be made is simply one cannot claim historical interpretation, perspective, or understanding to be accepted if there is no evidence that proves it. Historical claims require evidence. Next slide. For the remainder of my time, I want to briefly cover, I'll be really fast to cover the law on armed carriage as it developed over the course of the 19th century. It's rather important given that many of the firearms controls that are in place today developed over that period. This is particularly true of armed carriage licensing laws. In the early half of the 19th century, there are essentially two types of laws: concealed carry prohibitions and the Massachusetts model. While the former is self-explanatory, the Massachusetts model was essentially a modified, updated version of the Statute of Northampton, and the Massachusetts model sought to prohibit the dangerous carrying of weapons in public places unless a person faced an imminent threat to their safety. If an individual was caught carrying in public, the legal burden was on them to prove that their carrying was reasonable and necessary. In this regard, the Massachusetts model was quite flexible and consistent with common law practice. However, come the mid to late 19th century, between increased migration, the mass production of firearms, and enhanced lethality of firearms, the law of armed carriage was once again modified. While concealed carry prohibitions continued in many jurisdictions, the Massachusetts model was revamped in one of two ways. The first was the model surety process was eliminated and replaced with fine and imprisonment. The second was the arrival of laws that required individuals to acquire a permit from the mayor or chief of police. These laws appear to have originated in California or Kansas and somewhat vary jurisdiction to jurisdiction. Most jurisdictions, however, gave the permitting official virtually unbound discretion in issuing and revoking permits. Can you go to the next slide? Here's a copy of what a permit looked like circa 1890s. I just want to show it so you know it actually did exist at the time. There are actually some permit records available for research. I have not been able to make it to those archives to look at them yet, especially under COVID. Next slide. And next and last slide. This concludes my time. I'm looking forward to your questions and hearing Stephen talk. These are just some recommended readings if you're interested in learning more about what I had to say here. I think we'll get into maybe rebuttal time more about what I think with the case and maybe standards of review. Because no reason to rehash everything here if and we can get to that later. But again, thank you for your time and thank you, Barbara.
Of course, thank you so much for that, Stephen. Do you want to give us about 20 minutes of your thoughts?
With pleasure, Barbara. And thank you all for putting this on. It's a real pleasure to be here remotely. I spoke at your university years ago, back when we had face-to-face meetings. Patrick and I have had discussions of this type before, and we aren't quite a roadshow yet, but it's always a pleasure to exchange views. I want to focus on the issues in the Bruen case and look back at the various textual, historical, and traditional aspects of this issue as we go through the case. And of course, we always should start with the text, which is the pertinent part: the right of the people to keep and bear arms shall not be infringed. Pretty powerful words. The people, you see that in the First Amendment, the right of the people peaceably to assemble. The Fourth Amendment, the right of the people to be secure in their persons, papers, houses, and effects from unreasonable searches and seizures. And it was not until maybe the 1960s that the theory was invented, somewhat by courts, also by academics, that the people really doesn't mean the people, it means the militia, and today the militia is the National Guard. So no person has a right to keep and bear arms. States have a collective right to maintain militias, and there's several variations of that theory, but it was put to rest in the Heller decision in 2008 by the Supreme Court. But the right of the people to keep and bear arms, it's not just a right to keep arms, such as in the home, it's a right to bear them. By any definition, the term bear includes carrying arms. So that doesn't mean there aren't textual restraints. For example, you have a right to bear arms that could arguably not be, would not include something that you could not bear, like some kind of heavy weaponry like artillery. You can bear small arms in the modern context, rifles, pistols, shotguns. In older times, it was spears and bows and arrows and swords, daggers, things like that. That's what arms are. So if you begin with the text, it seems pretty outright obvious that the people have a right to bear arms. And that's being challenged, though, in the New York State Rifle and Pistol Association versus Bruen case. What all sides agree that the people have a right to bear arms, but New York has a very narrow definition of people. They only include non-typical people who have what New York says, a non-speculative reason to carry arms. And that has to be approved by a government official. So it's kind of a weird, odd definition of people, only non-typical people. If you look at the New York State case law on the subject, it's clearly stated that you have to show proper cause in order to get a handgun carry permit. And what is proper cause? I mean, that's such a weaselly, slippery kind of term. And it comes down to this: you have to be somebody really special. You have to have a special need. And that need does not include living or working in a high crime area. because gee whiz, then you're just like everybody else. So you don't qualify for a carry permit. But if you're Robert De Niro, a person who likes to denounce the Second Amendment and gun owners, you get a carry permit. Donald Trump had a carry permit, a billionaire. And as came to light in the last few years, if you pay the right bribes in New York City, you could get a carry permit. You pay money, you provide prostitutes, you buy baseball game tickets and trips to the Caribbean. There were several people in the firearm licensing division in New York City busted and prosecuted and incarcerated for selling pistol permits. And if you have a shall issue regime where if a person meets objective criteria to get a carry permit, it doesn't really lend itself open to corruption of that type. But if it's may issue, if a government official decides whether you can exercise this constitutional right, then it is open to corruption. So one of the striking moments in the oral argument, which took place on November the 3rd, was anytime the Chief Justice opens his mouth and people kind of wonder what the Chief Justice might be thinking because maybe he doesn't have a track record on the issue, everybody really listens. And what he said very emphatically was that we don't go back and look at, for example, the Statute of Northampton of 1328, passed during the reign of Edward III with very archaic language. And while we're on the Statute of Northampton, the Chief Justice wasn't interested in it, but I'm going to read a phrase from it. No person shall bring no force in a fray of the peace, nor go or ride armed. And some people take that to mean, well, nobody could go armed ever. But no, the phrase no force in a fray of the peace was read by English courts to mean that basically the statute applied to going armed in a fray of the peace. And that it was so interpreted in treatises for magistrates and various officers in enforcing it, and by English court decisions in the early 1900s. So anyway, Chief Justice Roberts says, well, we're going to look at text and we're going to look at the Heller decision. Why don't we start with that? I mean, that's the Supreme Court's most prominent precedent on the issue. The one thing that the New York lawyer, Ms. Underwood, could not do is give in the briefs or the oral argument, a textual refutation of what the actual words are. It just so clearly says that people have a right to bear arms. And so what can you do about that other than to make arguments about, well, only atypical people with a special need? And then Heller, in the 2008 opinion, goes into the meaning of keep arms and the separate meaning of bear arms. And it means to carry an arm, to carry some kind of weapon in the pocket or otherwise. There was a dissenting opinion by Justice Ginsburg on a different kind of issue, but it had to do with carrying firearms. And she mentioned the Second Amendment as being the one example of what it meant to carry arms or to carry firearms. So just in terms of a linguistic analysis, bear arms simply means to carry arms. And that doesn't mean there aren't restrictions of any kind. And that's a red herring to say that those who support Second Amendment rights think there's no restrictions of any kind. But what is clear that the basic right is there, and there has to be some kind of way of or methodology or jurisprudential method of deciding what exceptions to constitutional rights exist, because the basic premise is that the right should govern. The other thing that Chief Justice Roberts had to say that was striking in the case, the lawyer for New York was arguing that, well, maybe it's okay to give carry permits to people who live in rural areas, or to give permits that only allow certain things like going to the shooting range or going out in a forested area where there's a bike trail. And Chief Justice Roberts asked her how many muggings take place on the street and on bike trails in rural areas. And then as the transcript shows, laughter. Everybody in the court laughed. Well, it wasn't many people in the court to laugh, actually. Only the justices and the lawyers were there, and then a select group of media. And by the way, by all means, if you're interested in this area, go to the Supreme Court website, listen to the oral argument. It's very lively, very entertaining. And you see things like when the Chief Justice sort of tells a joke that you won't see in whatever the opinion is going to be. So the New York attorney came back and said, well, yeah, there are violent crimes on bike paths, like there's attacks, there's rapes and things like that. And that really only, I think, made her case worse because, okay, that's very true. You can be in isolated areas and be attacked, but you can also be in very populated areas like subways in the middle of the night and be attacked. There's another case that the court decided 2 years after Heller. It was McDonald versus City of Chicago. And that had to do with whether the Second Amendment applies to the states through the 14th Amendment. Right after Heller was decided, there were several lawsuits filed against Chicagoland jurisdictions, which also had handgun bans. The only handgun bans in US history basically were those of the District of Columbia, Chicago, and then a few other suburbs of Chicago, Cook County, for example. So then the question became whether the right to bear arms, or the right to keep arms actually in that case, applied to states and localities. And the court came back and held that yes, it does. And that opens up a historical issue. The court looked at the context of the 14th Amendment and what was going on that gave rise actually to its ratification. After slavery was abolished by the 13th Amendment, there were still laws that restricted African Americans in a special way. The old slave codes were reenacted as the Black codes. And in fact, if you read McDonald, you'll see the very first instance of a Black code provision that the type of law that the 14th Amendment was meant to get rid of was a Mississippi statute from 1865, which said that any person who's any freedman, any freed slave, any person of color to carry a gun had to get a license or a permit. And that was a good example of maybe that was the first kind of may issue license that was enacted in American history. And it was not just an equal protection issue. What is outstanding in the debates that led to the 14th Amendment is that all Americans, all citizens have a right to keep and bear arms. And it's not just a question of discrimination. There could not be a law that would be passed that would ban gun carrying or possession by everybody without a license. And so here we have an early instance of a so-called may issue law. Before that time, getting back to some of the history that Patrick had touched on, at the time of the founding, there were no laws that prohibited the peaceable carrying of firearms. There were, I think, 4 colonial laws, and then there was a Virginia law from the 1790s and a Massachusetts law about the same time where it was enacted that it would be unlawful to carry an arm or to go armed offensively to the terror of the country. And so there you have various elements of the offense. You have to carry the arms, number one, and number 2, it has to be in a way that to terrorize others. And that goes back to Sir John Knight's case that Patrick mentioned. We have 2 court decisions from the King's Bench, 2 versions of the decision. Sir John Knight in 1686 was charged with going armed to the terror of the subjects. And that was basically what the crime was seen as being. It was not just going armed. He carried guns to a church service. we didn't know much about those decisions other than what was reported until in more recent times. There were diaries that were discovered that had a lot of detail about the Knight case. But basically, what we know from those decisions, and that's all the founders would have had access to, was that he was charged with going armed to the terror of the subjects, and he was acquitted by the jury. We don't know why. It was I wouldn't attribute what a jury decision to some kind of ulterior motive. Well, what we know is that the judge, the chief judge, explicitly stated in the decision that the crime involved going armed malo animo, with bad motive, in other words, to the terror of the subjects. And he didn't do that. He simply carried arms, period, and didn't terrorize anybody. Going back up to the early American founding, at the time the Constitution was adopted, there weren't any restrictions on carrying in a peaceable manner. But then we have the concealed weapon laws, mostly in the southern states, being enacted in the antebellum period. And we have what's called the Massachusetts model, which meant had to do with, you could carry arms, but if somebody complained, if there was cause to believe that the person was carrying arms in a manner that would be a breach of the peace, that would have to be proven to a court, to a magistrate. And then the burden shifted to the person going armed, and the person would have to prove that he or she was carrying arms in a manner that for self-defense purposes, legitimate self-defense. And if not, then the person would have to get sureties to keep the peace. That's all that was on the books in the antebellum period. And it really wasn't until the turn of the century. I mean, we have the Sullivan Law of 1911 enacted for New York and Massachusetts about the same time period. For the first time, you do start having enactments where you had to get a permit to carry a concealed weapon. Now, a lot of states, even those that had that, you could still carry openly. I mean, New Jersey today is one of the most restrictive states nationwide, but you could still carry openly up until 1966, which is as incredible as it may seem. I'd like to get back to the oral argument a little bit. Justice Kavanaugh most emphatically formulated the reliance on text history and tradition in the case called Heller 2, which I litigated. It was a dissenting opinion, and nobody knew at the time that he would later become a justice, obviously, but that was the formulation. And in the Bruen case today, the parties are basically briefing that case as if text history and tradition will be what the court will be relying on. Now, Justice Barrett, I did speak, asked a neutral question about sensitive places and where persons might carry. What were the limitations on carrying? And there's something that is not well known. She did, as a Seventh Circuit judge, author of Cantor versus Barr, a very well-known, lengthy dissenting opinion on the Second Amendment. But there was a majority opinion that she wrote that is not well known, where she basically said that the police should not be engaging in warrantless searches about people who are exercising their constitutional right to bear arms. So I think that she's sympathetic to the idea that the people at large have a right to bear arms. That came out in the oral argument very emphatically, because the question was asked, is that how we interpret other constitutional rights, since you have to get the government's permission and show a special need, like to exercise your right to free speech or freedom of religion, something like that? Well, of course not. I mean, even Justices Kavanaugh and Sotomayor bore down on Ms. Underwood, the New York attorney, on that issue, because she was not responding in a way that really answered the question. She said things like, well, under really old English law, you had to get the king's license. Well, that doesn't answer the question. How do we interpret constitutional rights? Isn't there a presumption that you can exercise the right and you do not need government officials' permission? Justice Alito spoke up for the common person. Everybody knows in New York City, you don't get a license unless you're somebody really special. And he said, what about the fact you've got all these regular workers? They might be janitors, nurses. They get off work at midnight. They've got to go down to the subway. They have to go through high crime areas. What about them? And the attorney said for New York said, well, no, they don't get permits. And unless they have some kind of special need or special reason. And so Justice Alito said, oh, so you have to know that you're going to be mugged on a specific Thursday night to get a permit to protect yourself. And then he also asked, well, aren't people carrying guns anyway in subways and other places? And the New York attorney said, well, yeah, illegal guns. And yeah, that's our point. That's the whole point of the idea. If we go from the text of the amendment, which says you have the right, and you go to the practical issue, that's why we have a need to exercise that right. That's why those who are considered little people, common people, they've got the same right as all the rich people and the celebrities who get to carry permits to protect themselves. So a lot of the argument had to do with, let me back up a little bit. I haven't mentioned Justice Breyer. Justice Breyer had a lot of questions. He always has a lot of questions which he asks without giving you an opportunity to answer the question. And then finally he stops and you try to address the questions. But he basically said, well, okay, if everybody who shows they've got the training, they've got a lack of criminal record, things like that, they're reliable people. If all those people who choose to do so could get permits, well, shucks, they'd be going to baseball games and getting drunk, and then they'd start shooting people. And Paul Clement, who argued for the petitioners in this case, responded, Your Honor, this is not the experience of the 43 cases that have shall issue. In my analysis, it's actually 44. In fact, half of those states, 21 of them actually have constitutional carry. You don't even have to get a permit or a license to carry openly or concealed. And Mr. Clement said that this hasn't happened in these other states. The sky hasn't fallen. There's only 6 states now that have may issue. And how is it any different in those states? I mean, Vermont has never had a requirement of a license to carry openly or concealed. And it's always had one of the lowest crime rates nationwide. Crime rates are engendered by a lot of different factors, but certainly they're not promoted by shall issue carry regimes. One thing that Patrick mentioned was the may issue laws that where you have to show special need that were enacted by the lobbying, I guess, by the U.S. Revolver Association or other groups. That's always been subject to abuse. In the 1950s, and the boycott over segregated busing in Birmingham, Martin Luther King his house was bombed. His wife and his child, they were there. He went in and applied for one of these may issue licenses, and it was the same formulation in the wording as these several states had adopted, where you had to show, once again, some kind of special need. The sheriff denied the license. He hadn't shown that special need. And what's the excuse has always been, well, even if you, pardon me, I forgot to turn my phone off. Sorry. Even if something has happened to you in the past, well, you can always call law enforcement and they'll be there. They've got your back. So what besides text, history, and tradition, what are other methods that courts have used to look into rights and determine whether they've been violated? And then we get back to levels of scrutiny. There was opposition, especially from Justice Kavanaugh, on that type of model. But what's been happening and what gave rise to this court getting certiorari granted, I think, is the misuse of levels of scrutiny. We've got strict scrutiny, which is a very high standard. The government has to show a compelling state interest to restrict a right. And then we've got so-called intermediate scrutiny. And intermediate scrutiny, the element of being narrowly tailored has always been there, but the courts below that have been upholding these different restrictions have never looked into whether they're narrowly tailored. They just say, oh, well, there's the police power, crime is something that's a legitimate thing for government to repress, and therefore they uphold these laws under the most non-stringent standards. I mean, if you go back to New York City, the New York City case that the court disposed of in the last term, you could not take a firearm out of your premises, out of your house, if you only had a premises permit in New York City. And basically you couldn't take it anywhere. You couldn't take it to upstate to your second home. You couldn't take it to a shooting match or a range down in New Jersey. And so a police official filed an affidavit saying that, well, it would be a threat to public safety if you allow people to take their gun out of their house. And so people might get road rage. And even though these guns were being carried in the car trunk, unloaded, secured, inaccessible, locked. And that was enough for the U.S. Court of Appeals for the Second Circuit to uphold that New York ordinance. And once the Supreme Court granted cert, the city was just beside itself to get out of the case. And they started by writing letters to the court saying, we're going to change our law. The court said, no, you got to brief this, and it went to oral argument. And when it got there, they couldn't find any legitimate purpose for that law. Justice Ginsburg asked a question like, are you still saying there's some kind of compelling public interest? And the lawyer for New York City said, well, like, not really, Your Honor. I mean, they couldn't think of anything because they tweaked their law to get out of the case, and then it worked. The court said it was moot. But that's just an example of the misuse of so-called intermediate scrutiny. You can find a way to uphold any restriction.
Stephen, I promised to remind you when we hit 20 minutes, and we're a couple minutes past that. So I don't know if you want to wrap up or provide some extra thoughts. We'll give Patrick a chance to respond.
I'll just wrap up real quickly. Just a disclosure, I filed a brief on behalf of the National African American Gun Association in the case, which goes into the antebellum laws that apply to persons of colors and slave, and also went into the Reconstruction history and the Jim Crow history. The gun laws have always been used in a way to discriminate against various kinds of minorities. There was a brief filed by the Italo-American Association about the Sullivan Law and its origins, and which had to do with a lot of anti-Italian prejudice. And I think, Patrick, you're going to mention that, and I think you might be speaking tomorrow. I think you said it on that at a conference. But just one last point: New York's ultimate statement in its briefs and an argument was that if you're going to rule against us, instead of doing that, why don't you just remand the case for further fact finding? And I would just say that would do no good whatever. There's no facts that need to be determined. New York law is clear that you don't get a permit unless you show a government official, convince them that you have a special need other people don't have, and that doesn't reflect our constitutional values. That does not reflect this being a constitutional right. I'll stop there.
Yeah, thank you. Thank you for that response, Patrick. A lot there that you may want to respond to, whether levels of scrutiny or the history or other gun rights cases. So I will leave it to you to pick and choose what you'd like to respond to.
Yeah, I think we'll get into the scrutiny, I think, through the questions. I think that's very important. But I think I want to start off just really quick, get us back on track. I'll be quick. Where Steve and I agree, right? There's real concern when you're talking about discretion in the law. There's a big chance for abuse. And I think that's why this case, you see a lot of justices leaning towards striking the law down. You know, it doesn't sit well. I don't think it sits well with anybody. I think we'll also agree with Stephen that, text is important, right? Text is a big driver of not only how we interpret any statute, but especially the Constitution. With that said, I think I disagree with Stephen in a way, like, just because it says bear arms, it doesn't mean that we don't look to history and tradition to define, the contours of where and where not you may bear arms and in what circumstances and who may govern that. We look at the Fourth Amendment history, with especially the English history and early American history for, what constitutes a seizure and, what constitutes as papers. And then, jurisprudence develops and then, over time, but, there's always, initially when we're trying to define these things, we look a little bit at history, tradition, and then common sense and test will start to kick in because the present's not the past, right? And that's especially true with the Second Amendment. You have a gun that they were carrying in the 18th century that maybe you could fire 2 shots in a minute. And you certainly couldn't carry loaded because if your powder got wet, it wasn't going to fire. You couldn't put it in your holster. The round may have fell out unless the paper was patched just perfectly. It's different times, right? So, there's only so much the past can tell about the present. But the reason that English history is important, the Statute of Northampton is being considered, not to say I agree with it, but when they brought in Heller, they brought in English history, and they said this was a right carried from the Anglo-American tradition. And the Statute of Northampton, like many English laws at their time, were brought into American law. Most of the laws and understanding of the law and the limits of rights, criminality, misdemeanors were carried over from England. They fought for English liberty when they fought the American Revolution. Now, yes, that's American conceptions of English liberty, but it's English liberty nonetheless. And they look to Blackstone, and they look to, Hawkins or Dalton and others to kind of help define those rights. So English history does matter. On the Statute of Northampton, I concur with Stephen. The Statute of Northampton prohibited bringing armed force affray, but it also says nor go armed, in fairs, markets, and whatever. If you look at treatises and you look at other documents at the time, both are covered under the Statute of Northampton. In fact, there is a great early document from the 14th century where they're trying to enforce the statute. It says all the articles of the Statute of Northampton on carriage need to be enforced. All the articles, not one, all, which means there were several aspects of carriage that sought to prohibit. Whether that matters, we can debate that. I did want to talk about, Stephen mentioned something about, how the Sullivan Law was kind of like these modern laws weren't until then, these main issue laws, or that it was Mississippi. Yeah, I don't think anybody contests that there were black codes or slave codes that disparaged or, were discriminatory against, people of color, free and slave. But yeah, these laws started in 1865, and when they started, the idea was that they respected the Second Amendment. They were better than concealed carry prohibitions. They offered a way for people to carry weapons at certain times. I don't think they were so concerned with the discretion problems we have today. Not to say they didn't develop, but that was the idea behind them, and they grew. And in New York, when Sullivan passed their law, already 8 of their major municipalities had may issue regimes in place, at least 8. There may be more. I can only unearth so much under code that I can't go to New York and go to every town and city and look up their old ordinances, but I've done what I can to kind of show that this is a part of history tradition. And with that said, right, this is really the difficult question, right? You have a law that doesn't sit well with justices, but at the same time, we have a long history and tradition of these type of laws, longer than any other gun control or firearms control or restriction on the books that I know of. And, if this law doesn't survive and they strike it down on history grounds, then I don't think any law will survive, right? Now, if they say, hey, history and tradition supports this law, but there's other reasons why we find it problematic, we think we should, either curtail it or limit it, or you need to come up with better criteria to define when and when not to issue someone a license under, a cause of self-defense. I could see that happening, but we can go get more in those particulars, but that's all I have for a rebuttal response for right now.
So I heard Patrick highlight 3 areas of agreement. And since this is such a hotly contested issue, I just wanted to reiterate that there are areas of agreement. I heard those One, to be that the text is important, so I appreciate that we agree on that. And two, that government bureaucrats exercising discretion are bad. I'm happy to point that out as a point of agreement. And then finally, it sounds like we agree on the text of the Statute of Northampton, but not its meaning. So at least a very small area of agreement with respect to history there. Stephen, briefly, anything you'd like to say? And then I do have a couple of questions for each of you, and I see some of our audience members do as well.
Just 2 points, Barbara. We did inherit our rights from our rights as Englishmen, but not part and parcel every restriction. If you go to the English Declaration of Rights of 1689, you have rights of Protestants to have arms for their defense and security, basically. No question it was an individual right. The Statute of Northampton was no longer being used to prosecute anybody. I mean, that prosecution failed against Sir John Knight, and if you go after that period, there just wasn't any record of that. But we threw off so much from England. You know, the Declaration of Rights also declared the right to petition, but England had a restriction on petitions where it was called tumultuous petitioning, where you could not have more than 20 people sign a petition and give it to Parliament. And otherwise that was a crime. We did not inherit that. And we did away with so many of these monarchical practices. So that's where certainly we should look at English history, but more so to the kinds of rights that Englishmen were deemed to have as they increased in scope over time. And the second point is just something that I neglected to mention at my opening. But one thing that Paul Clement made clear was that as to these sensitive places where guns can be banned, Heller mentioned schools and government buildings. And I think what Paul said was a good way of looking at this. Courts, for example, have security. They have magnetometers. They have armed guards. They have the sheriff's deputies and so forth. So, I mean, that's a real gun-free zone with on steroids. I mean, that's where it can really exist, where you can't have like mass shooters come in and just like with a gun-free zone where it's only declared to be one. But I think that's a useful way of looking at this. Does the government provide security so that they have a legitimate reason to ban you carrying a gun there because they're screening people and because they're providing security? But otherwise, they have no duty to basically protect you. There's a lot of cases that hold that, and you're on your own to protect yourself if you so choose. So I'll end it there. Let's get to some questions.
Sure. So you've opened it up to also the history of the right to petition the government. That's what I heard you say. We can talk about that. But also, and perhaps more importantly, regulations regulating the carry of weapons in sensitive areas, which is particularly an aspect of the New York regime that the petitioners here disclaimed challenging. So they're not challenging it in this case, although something that undoubtedly is coming through the pipeline in cases after this. So I will start it off with a question, and then I see we already have 4 or 5 from the audience. Just as a reminder, if you are in the audience and do want to ask a question, please utilize the raise hand function on Zoom. It's the one that looks like it's giving you a high five in the bottom of your screen, and then I can call on you. So my first question, and I will call this the friendly fire question. Since you're both good and thoughtful and thorough historians, what piece of historical evidence have you come across that you think is most persuasive for the other side's case? So I think we can agree here that the history, kind of cuts both ways, or you can look at it from both perspectives. If it were clear and obvious, this case wouldn't have gotten to the Supreme Court. So from your perspective, what's the worst piece of history for you, or what's the piece of history that supports the other side's view of the right? Patrick, if okay, I'll start with you.
That's a real tough question. I think I'd answer it like this. If you pick and choose your history, your historical friends, your time period, or your jurisdiction, this case can come out either way. It can come out in favor of petitioners or the respondents. I've always said if they pick the antebellum South as the baseline, right? A lot of antebellum South cases said you can prohibit one or not the other. Then they're going to say, okay, well, and this is one of the main arguments that they've made is, this is, we should adopt this. It's closest to the founding, and that this is the most reflective of it. Now, is it the founding? No, because you're talking about cases, the earliest was 1822, so you're talking 31 years after the fact of the Bill of Rights. And if you think about that, that's, if we want to talk about the internet between now and, the 1990s, completely two different things now, right? Times change. History's not a monolith. Ideas change, values change, culture changes, technology changes, immigration changes. So this is what is so difficult about this case for these justices is that, I'm concerned if they do Texas history and tradition like really hardcore, that they're going to end up overturning most gun controls. And most have been enacted. The ones that are on the books now, most have been enacted at the behest of gun rights advocates. That's before the 1977 Cincinnati Revolt. But that's for a whole nother debate.
And Stephen, do you have a piece of history that does not support your view of the Second Amendment? What's the best piece of history on the other side from your perspective?
There are some parts of history where Patrick is right and where the other side is right. What I was intrigued to do when I wrote my recent book, The Right to Bear Arms, which, by the way, came out 4 days before the court granted cert, which was very timely because the book is on this subject. But in looking at these manuals for magistrates and justice of the peace about the Statute of Northampton, it's true that there were several of those that interpreted this prohibition under Northampton of going armed to mean if a magistrate sees somebody going armed, you just arrest them. And there are other manuals of that type where that was not the case, where they would say if they're going armed in a way that's to the terror of the subjects. And so to the extent that an argument has been made that Northampton was never interpreted to prohibit peaceably going armed, that's not true. Some of these manuals, and you might even find some in early American history where these manuals didn't make that distinction. But I think the predominant rule and the rule that was adopted in America based on like Virginia and Massachusetts statutes was you had to go armed offensively to the terror of the country. So this might not sound like a huge point in terms of what the court might do, but in terms of people like myself and Patrick who really get into the history all the way back to 1328, I certainly make that concession that under English law you had restrictions on guns that applied to basically people who were carrying. I think the way they were enforced, it was against people who were carrying to commit crimes, but that's a historical fact that it cuts both ways in some cases.
That's good. So we've heard the case from each of you. We've heard some areas of agreement and maybe a couple of concessions from each of you that there's some history on the other side of the debate. So I feel like, my job here is done, and I'm happy to turn it over to the audience for some questions. I see we have some queued up. So first, top of my list right now, it looks like Matthew Arnold has a question. If the moderator could unmute him, and we'll get to that one.
Got it. Can you hear me? I just unmuted myself. Outstanding. So first off, thanks both of you for presenting a very informative debate. I think that the delving into ancient English history is certainly interesting, although perhaps not quite as relevant as we might think. As Mr. Halbrook pointed out, yes, English history and common law do inform American law, but it's not identical. We made a very conscious break with a number of English traditions, including, most importantly, the fact that Americans are citizens and not subjects. But getting to the question, so Heller not only affirmed that the Second Amendment was an individually protected right, it also affirmed the core purpose of the right being protected was individual self-defense. And just a couple of questions along those lines. So do people lose the right of self-defense on leaving their home? What other constitutionally protected rights are restricted to being exercised only in the home? What other constitutionally protected rights require a government permission slip to exercise? What other constitutionally protected rights are restricted to a privileged class that can attain access to exercise that right because of their political or social connections?
Good questions all. Patrick, I will let you choose which order you'd like to take those in.
Well, I think to be fair to other people, I'm only going to answer the first one because I didn't have time to write them all off. We'd be here all night. All good questions. Self-defense in the 18th century, we can just talk about that, right? Our conception of self-defense today is very different than it was in the 18th century. You had a duty to retreat to the wall in public, where you didn't have that duty when you're in your home. You had the castle doctrine, right? So the point is, and if you're going to take 18th century as your baseline, you didn't have a right to do this, to go, to carry and go, okay, well, now I'm going to, stand my ground. That's not how the law worked back then. And I bring that up because, most people, when they talk about the founding fathers, they just presume like, hey, what I do now or how I interpret self-defense, they interpret it that way. It's not true. It's evolved over time. I mean, now it's so laissez-faire that it's becoming more and more difficult to prosecute people on this. How, if at all, I think the interesting part of this is like, right, it was a question I think Chief Justice Roberts asked. He says, if we take Heller as true that self-defense is the core right of the Second Amendment, I believe then he followed that up with, well, does how many muggings take place in the woods, and wouldn't you need that right mostly where you'd be around people? Yes, right. I think he's right on that. However, it's not just your liberty and interest that's at stake. It is everybody else around you. And with modern firearms, especially, the fact that you could shoot off 30 rounds in a second is problematic, and that things are so close and compacted together. So when we think about, this is what makes the Second Amendment unique. It's not the First Amendment. If I yell at you, it doesn't change that I yelled at you today if I yelled at you in the 18th century. I still am yelling at you. I'm an individual person. It's very different today with the firearms. But even then they had laws against, the firing of weapons within a quarter of a mile of any townhouse or anything, unless it was for, determined for self-defense. And also, the burden was on you to prove you needed self-defense. It wasn't on the prosecution. So things are very different today. So I hope that answers your question. They're good questions, but I just don't have time to answer all of them.
Stephen, would you like to weigh in on those?
Yeah, there were briefs filed in favor of New York saying that you shouldn't recognize this right to bear arms on the part of the common citizens because we have rules about deadly force. And I couldn't agree more. We have rules about deadly force, and if a person gets a carry permit, they're bound by those rules. I'll add, just to follow up on Patrick's comments, and just a strict self-defense situation under the English common law, there was a duty to retreat if you could retreat. If you read Blackstone, that's very clear. But you also had a duty to enforce the law. If a forcible felony, for example, was taking place and you needed to do something to prevent it or to stop it from happening, there was no retreat rule there. Things like a robbery taking place, you didn't have a duty to retreat from a robbery. The duty to retreat rule more or less applied in cases where you might have even been a little bit at fault by arguing with another person and maybe provoking a fight. And so today we have different state laws. Massachusetts has a duty to retreat, but in the case of stopping a forcible felony like a robbery, there's case law saying you don't have a duty to retreat. I think in the Northeast, there's more duty to retreat than in the other states. Florida is a good example of the so-called stand your ground state. But no matter what kind of license or to carry, or whether even if you don't need a license, you're subject to all of these state laws about the use of deadly force. And it comes down to you cannot use deadly force basically unless you're threatened and you reasonably perceive that deadly force is being used or going to be used against you. So I think that's really a non-issue to say that to argue against or to argue in favor of may issue based on the fact that we have rules about the usage of guns. Certainly we have rules on the usage.
Well, and certainly neither of the two of you is backing down in this debate, so I appreciate that. That's my tie-in. Let's go to Michael Concannon. I see you have a question. If you want to unmute yourself and ask.
Certainly. So when I look at the history of the Bill of Rights, I see a long march of incorporation and expansion of rights as we have realized that our intuitive attempts to limit those rights to find the best balance failed again and again and again, whether that be women's rights or slavery. He mentioned, Mr. Charles mentioned the 1967 gun control law in California supported by Reagan. I believe that was in response to the Black Panther uprising. So again and again, we've seen that our attempt to find the reasonable balance in laws has resulted in abuses to horrendous abuses. So we have increased our interpretation of these liberties one by one, our First Amendment rights, our Fourth Amendment rights, our Fifth Amendment rights. So the first question is, what's special about the Second Amendment that says that it is not entitled to the same broad and expanding interpretation of liberty that we have applied to the rest of the Constitution? And my second question is, if we have evolved and adapted and grown as human beings in the last 250 years, why are we less worthy now of that liberty than we were at the founding of this country?
Patrick, do you want to start again? An expansive view of the Second Amendment as opposed to our view of other rights?
Yeah, I don't know if I agree with his conception of how rights have come about and maybe the tug of war that takes place. So I think we're at odds there. But what makes the Second Amendment special? Well, all the rights are special, right? They all have different pedigrees. They were all different backgrounds and traditions from which they were born. If I presume, Michael was talking something about a presumption of liberty, maybe because he's talking about broad, these rights protecting very broad liberties, even the First Amendment. And my understanding of the First Amendment is that that's completely untrue, right? And also, the Bill of Rights only protects against federal and state action, right? Against government action. It doesn't protect against everything. So I think there's often a misconception that, and I think everybody hears all the time, like, you're interfering with my First Amendment right. Well, one, I'm not a state actor, so no, I'm not. There's so many problems with that. And the same with the Second Amendment, right? So the Second Amendment doesn't give you a right to carry guns on my private property. It's my private property. You do not have the right to carry guns on my property. And that's with everybody. Everybody has that right to exclude you from carrying on their property because it's theirs. Now, conversely, you can, and I think the Second Amendment protects this, you can carry guns all over your property. It's your property. Can you, do what this couple did, I believe it was in St. Louis or Missouri, somewhere in Missouri, where they brandished firearms? No, that's against the law. But, right, there are, I guess my point is saying is that history and tradition inform that there are restrictions and no rights are absolute. And I don't know of anything, and maybe Stephen knows something where this, I think you're talking about a presumption of liberty. And I also will counter, I do want to point out, you brought up the Black Panthers and the '67 Mulford Act. That is true. Without the actions of the Black Panthers, the Mulford Act would not have been passed, I think, as quickly as it did. However, you have to understand that people were not using firearms at that time to walk around and to protest. The Black Panthers also were giving, not all, but some were issuing threats against law enforcement. And using arms to deliver a political message was considered dangerous, and they weren't the only ones. there were groups of white vigilante groups in California trying to do the same thing. And the government just basically tried to quash all that because they saw the dangers of something that may happen between the two groups. Now, the NRA supported quashing those laws, or basically restricting the open carry in the way at least the Black Panthers were doing it, is because of the danger it imposed to the public and to safety and to other people's liberty. The NRA at that time didn't think you had to carry a gun to exercise your right to free speech, but many Americans today somehow believe that I carry my gun to extend my right of free speech. That is not how it's ever been interpreted until recent times. That's a new invention that's been created.
Stephen, anything you'd like to say on a more expansive view of the Second Amendment or other Bill of Rights?
Just one clarification. The St. Louis case involved the McCloskeys. They were two lawyers. They were at their house. This group of demonstrators broke a gate and went through and started, there's plenty of evidence they were yelling threats at them, like, we're going to burn your house down, we're going to get you, things like that. And so they held the firearms. Mr. McCloskey had an AR-15, his wife had a pistol, and they were charged with basically a brandishing offense under Missouri law. I've studied the statutes very carefully there, and you have a defense if you're doing it basically for lawful self-protection. They were charged, the basic felony charges were dismissed. There was a plea agreement. Look, I've done a lot of criminal law cases, and sometimes just to make a case go away, you would plead guilty to being a banana, okay? If you're going to get just a small fine and then the case is over. And that's what the McCloskeys did. There was a plea agreement, and then the governor pardoned them. We've got that issue about using force or the threat of force playing out right now. Everybody knows in the Rittenhouse case, and there's different narratives that are being written about that, but we'll see what the jury does. Just one other point, the presumption is in favor of liberty. Just using the Fourth Amendment for an example, there's a presumption you have to have a warrant. There are exceptions to the warrant requirement that the courts have come up with, but the presumption should always be that you have the right to be secure against unreasonable search and seizure without a warrant. By the same token, there can be exceptions to the right to bear arms, but the presumption should be that you do have that right.
Well, the question was about an expansive view of the Second Amendment. And for my own perspective, I'm just glad we don't have an expansive view of the Third Amendment, which is the prohibition on quartering soldiers, because I only have so many rooms in my house. Okay, sorry, I promised at the outset only one joke, and that was two, but you very rarely get to joke about the Third Amendment. So with that, I will turn to Charles Nichols. Mr. Nichols, if you have a question and would like to unmute yourself, that'd be great.
Yes, thank you. I did have a question, but I have to make a comment on the Mulford Act, since I'm the first and only person who's ever filed a lawsuit challenging the Mulford Act. And I'm about to begin my 11th year of litigation in that lawsuit. The bill that Ronald Reagan signed was not a hard ban on openly carrying loaded firearms. It provided an exception. If one had a reasonable fear of serious bodily injury or in defense of property, then one could load the firearm and carry a loaded firearm openly. As for the Mr. Patrick Charles' comment that there were white supremacist groups that was part of the motivation behind the Mulford Act. There is one letter, and I've read the Mulford file, all 700 plus pages from the state archives. There is only one letter that did not make reference to the Black Panther Party, and that was the initial letter to Mulford telling him that there were giving three instances. One, of course, primarily was the Black Panther Party for self-defense. The other was what one could characterize as a white supremacist group, and the other was a Neighborhood Watch group was carrying arms, and the police talked to them. They agreed to stop carrying arms in public. It was Jerry Brown who signed the bill which raised the threshold to openly carry a loaded firearm to grave immediate danger and only for the brief interval of time between notifying the police and their arrival. So, but, you know, don't blame it all on Ronald Reagan, because Ronald Reagan and the legislature, the bill was bad, it was wrong, it should not have been passed. They believed that there was a Second Amendment right to openly carry firearms. They responded badly to the activities of the Black Panther Party for self-defense. Now, that was, I hadn't planned on, that wasn't my question. I just wanted to comment on that. My question is this. The new, Mr. Clement and several of his amici say that concealed carry, prohibitions in concealed carry were only upheld because open carry was allowed. But if you look at the decisions cited by the Heller opinion favorably, such as Reed, Nunn, and Chandler, they all said that concealed carry is evil, and that is why they upheld the prohibitions on concealed carry. So what is the purpose? I don't understand. Do clerks and justices not do site checks? I don't understand why. What is the strategy behind making a legal argument which is patently false on its face? And that was my question.
Yeah, so as a former clerk, I can assure you there's plenty of site checking that goes on behind chambers. But I would like to give Stephen and Patrick an opportunity to respond, I guess, more on California gun regulations than expected, at least by me in this discussion. Although you're welcome to comment on that, or if you'd like to, as the commenter alluded to, comment on other states' open carry presumptions or other concealed carry regulations and regimes at the state level. I'll leave it up to you. There was a lot in that question. So Patrick, anything you'd like to respond to?
Honestly, I'm kind of confused by the question. I will correct, I don't think I said white supremacist. I'd have to look back at the video, but I don't think I've heard anything about white supremacist. And we can disagree on the history of the Mulford Act. I've done a lot of research too. I have all the archives on it as well. But that's for another time. I think the question was, and maybe Stephen will say I'm wrong, but the way I consumed it is, why are they making an argument about, a right to concealed carry with antebellum cases when the courts back then clearly said that it was evil and a wrong, and a lot of people did. You could find tons of articles and sources and documents from all across the 19th century saying that concealed carry was awful, right? And for different reasons, depending upon where you're looking at in the jurisdiction. So why would you challenge it? Like, I think what's interesting about the case is that they only granted cert on the constitution of concealed carry. They didn't say on the Second Amendment outside the home. However, during oral arguments, it appears that the court's open to looking at the entire regime, not just concealed carry. It'll be interesting to see how that weighs out. If it is just concealed carry, that's the problem that the petitioners have, because concealed carry until what we're talking about the 1980s was looked at as a bad thing. Now, even I will admit, I think most people will admit, I don't know anybody that doesn't, is that if you are going to carry, concealed carry is the way you're going to do it. You don't want to open carry. It's a bad idea. And the NRA agreed until recently, until the open carry movement went politically active. I think in 2011, the NRA was on record mostly opposing it. So yeah, that's going to be interesting because times have changed, and how does the court deal with that? And this is another problem with history and tradition, right? You can't rely on history and tradition completely because times change, cultures change, and there's actually great reasons now for not open carrying.
Stephen, any response from you, whether about the Mulford Act comments or about, what to do if the court gets history wrong, generally, or anything else that Patrick mentioned you'd like to respond to?
Well, the Second Amendment protects the right to bear arms. The first judicial decision was Bliss versus Commonwealth, and it said you cannot ban either concealed or open carry, because you could do both of those at the founding. But then that was followed by a handful, 3 or 4 other cases saying that you can't ban all carry, but you can ban concealed carry. That's considered an evil. But put that in context, it was only in the southern states and in Indiana and Ohio that had bans on concealed carry. Most states did not. So you don't have judicial decisions out of most of the states in the antebellum period. So we can't say that it's the rule that concealed carry is completely unprotected and that only open carry is. And if we look at the New York law, New York bans open carry per se, even if you have a license to carry. You cannot carry openly. The legislature of New York prefers if you have a license that you carry concealed. In fact, it mandates that you carry concealed. So this changes, attitudes change with the times. The argument that was made in the Supreme Court by Mr. Clement was that you have to allow either concealed or openly. You cannot ban both. And that's what some of the courts have said all along. So in today's culture, I think people don't want to see other people openly carrying in large cities where a large population, they're side by side, they're piled up on top of each other, the way Justice Barrett put it. So that's something for the legislature, but the reason the case has been framed this way is that concealed carry is the only option with a license in New York. Just a word about the Mulford Act. Look, I was a college kid in those days, and I paid a lot of attention. I was impressed when I first saw the platform of the Black Panther Party for self-defense. There was one constitutional right they cited, and it was the Second Amendment. And they made allegations that there was police brutality in Oakland, and they formed groups where they would go to the scene where the police were conducting the stop, and they would have their shotguns, and they were just there. Maybe there were arguments, but they weren't doing anything illegal. And it only became, the act didn't pass until they went up to the state capitol when it was in session, and they legally and openly carried their shotguns. And as a reaction to that, for better or worse, the Mulford Act passed. So there were certainly political implications to it. And it was just not the thing to do, that a bunch of African Americans were going to be there legally carrying shotguns. And that's what this Mulford Act was aimed to ban. Since then, of course, there's that act and other provisions that California has passed restricting any kind of carry. That's all in litigation right now. The Peruta case, the Ninth Circuit said California can ban concealed carry, and then that was followed by Young versus Ohio. They say Hawaii can ban open carry, so you can ban all carry, and that's what the court's going to resolve now in the New York case.
Thank you. I see we're coming up right on 8:30 Central. So let's, if the panelists are up for it, do one more question, and then we'll wrap up. Louis Brokatsky, I'm sorry if I slaughtered your name. If you have a question you'd like to unmute yourself and ask, that'd be great.
Yes, thank you very much for allowing me to ask the final question. Well, my first question is, does NYU have a campus? And the second one is in regards to maybe the extent of restrictions on be it open or concealed carry in regards to the type of firearm, maybe like maybe a short barreled rifle is not really necessary to protect yourself, and maybe also in regards to the attire you wear at the time of carrying, for example, paramilitary gear, which is also something that has come to the attention of the public.
Good question. And the NYU allusion, for those of you who haven't had the chance to listen to the transcript yet, there was a question whether NYU really has a campus in the discussion of sensitive places. So whether you'd like to talk about sensitive places or about restrictions on particular types of weapons, I will turn it over to you. Stephen, why don't we start with you this time, if you don't mind?
I can't remember if I've been to NYU. The question was also asked about Columbia. It does have a campus. It does have a yard. That case came up at George Mason University in Fairfax, Virginia. And the Virginia Supreme Court said that the only restrictions were in the buildings and at like the stadium. You could carry legally on the grounds. If you had a permit, concealed weapon permit, you could carry. And the court upheld those restrictions in that way. Campus carry is a big issue right now. There are different rules different states have enacted. I know Texas provided that if you have a permit, you can carry, or at least I think professors and maybe persons with permits who have to be, I think, 21. There was a litigation about that. Fifth Circuit held that there were 2 teachers that said that violated their Second Amendment rights because it was allowing other people to exercise their Second Amendment rights. And that was a frivolous case. And the court held against those teachers who didn't want anybody with guns on campus. So I don't know where this is headed, but once again, I think the rule should be if they're going to ban guns somewhere, they need to provide adequate security, because that came up in the oral argument as well. Clement was asked about that very issue, and he said one thing you cannot do is say the entire city is a sensitive place because we got plenty of cops to protect you. We've got your back. So we'll see where this goes. But once again, it's not going to be resolved by the court, but the court will most likely make some dictum about sensitive places.
And Patrick, any comments from you either on sensitive place regulations or on regulations with respect to types of firearms, or I think attire was also mentioned?
Yeah, I'll do the types of firearms. I don't think anyone, I'm sure there are people that disagree. I think constitutional scholars would agree that you can restrict certain types of firearms, assuming that the Second Amendment's going to extend outside the home. And I think we would, it says unmute myself. Can you guys hear me?
Yes.
Okay. Yeah, I mean, I think there's a long pedigree of restricting certain kind of weapons. They'll go into litigation as to what types, but I could see handguns being the one thing that, places like New York, or let's say New York gets struck down and they do a shall issue regime, they'll say, well, yeah, you can limit to handguns, and they may limit the type of rounds and magazine that you can carry, and especially the type of bullets, right? Different bullets have different powers to go through certain walls and so forth. So yeah, I mean, I don't see a court striking anything like that down unless it was absolutely ridiculous. And like you can only carry one bullet in your gun. I don't think that'd make much sense.
Thank you. I will pass it over to Leah to wrap us up for the evening with a thank you from me to both of our panelists and the great questions we had.
Thanks, Barbara. I just want to thank our fighters, Patrick and Stephen, as well as our referee, Barbara, for their insights tonight. And thank you all for attending. Stay safe and healthy, and have a great night.